everyone should have on screen a PowerPoint presentation which will keep your places as we speak. We're talking tonight about directors' duties during the pandemic and after it ends, which everyone hopes is quite soon. With me tonight's Angela Ipara. She's one of our smart young lawyers who's going to assist me in this presentation. We'll do the Bill and Ben game, and I'll speak to parts of it, and Angela will speak to others. Okay, this presentation tonight is not specific to anyone's particular circumstances. It's in the nature of general information, raises awareness about issues. If you've got a specific problem or if you need some specific help, we're happy to address that with you in consultation with your accountants. Please don't accept anything we say tonight as being the truth, the whole truth, and nothing but the truth. Also, what we tell you tonight is the state of play right at this very moment. As everyone's aware, COVID's come to us with a rush. It changes every day, every week. What's correct today may be totally wrong tomorrow. If the outbreak in South Australia blows up, we could be changing all the deadlines, all the timeframes that we're about to speak to fairly soon. So if we move to the next slide, we're going to talk about four things, and it's really a progression. Firstly, we're going to talk about or identify some of the effects that the pandemic's had on business, particularly the construction industry and related design consultancies, suppliers and contractors. Secondly, we're going to go through some of the government responses to the COVID crisis. Thirdly, the time frame that I just mentioned at present is that things will change again on the 1st of January in the new year, and we'll go through what will happen at that date, and then we'll finalise with some pointers about what your members ought to do in the lead up to that period to be in a position to secure their own situation and to avoid any risk in the new year. Angela, what are some of the effects that COVID's had on business?
So COVID, as we know, has affected a lot of industries and a lot of businesses in all sorts of industries, one of them being construction, the construction industry. One of the effects of COVID on businesses in the construction industry is the supply chain disruption. So all over the world, different countries have put in place COVID restrictions, and that will or has affected the supply of building materials and equipment. In addition, there's reduction in productivity, so government responses such as requiring businesses to have social distancing, that affects reduced productivity, labor shortages, and a big one that we'll be discussing tonight is the cash flow risks. So which leads to like some of the government responses to COVID-19. John, would you like to there's some background on that?
Okay, there's four categories of government response to the pandemic crisis. Firstly, the government's put in a lot of facilities for business by keeping the fiscal fiend off our backsides, getting the ATO to reduce the aggression that it usually displays towards many businesses. In particular, there's been a temporary reduction in enforcement activity by the ATO. If you're late with payments, they're much more ready to defer penalties, to defer payment schedules to come to payment schemes with you. From my experience, if you enter into a scheduled payment arrangement for your tax obligations with the ATO, so long as you keep to them, you'll never hear from them. If you miss a promised payment, you might hear further from them. In the current climate, it gives you a further opportunity to discuss the matter further with them. Importantly, as some of you will know, directors of a company, most of you are incorporated entities, directors of companies have personal obligations to ensure the payment by their businesses of PAYG withholding, the tax you withhold from your own employees. Directors have responsibility to ensure the payment by the company of its GST obligations. And thirdly, your companies have clear obligations to pay the superannuation guarantee charge on behalf of your staff. If your company doesn't pay it, the tax office will chase the directors personally. But during the COVID crisis, all those director penalty notice, PCNs, as the tax office calls them, have been deferred. They're not being issued at the present time. Finally, in relation to the tax office 12 months ago was the biggest party who would lodge liquidations with the Supreme Court or the Federal Court. Most liquidations were initiated by the tax office for unpaid tax. They've not been doing that in the last 6 months. In fact, the corporations list in the Supreme Court's been extremely quiet over the last period, largely due to the absence of the ATO. The next element of the government response has been direct payments. For example, many of you have taken advantage of the instant asset write-off arrangements. You can write off 100% up to certain limits of capital acquisitions for the purposes of business. So if you buy a new Amarok for your business, you'll be able to write it off in the same year against your income. Secondly, there's the cash flow boost arrangements. Now, arguably it's an ATO response to the pandemic, but in effect, you can get up to $100,000 in reductions in the your obligations to remit GST. You get a GST credit against your BAS in the June quarter that's passed and the September quarter that's passed. And those credits were equal to the tax that you withheld from your employees on their salary and wages. Another government scheme was the SME guarantee. The government guaranteed loans for small business, initially for working capital, and that's now been extended to business investment in plant and equipment for loans, whether they're secured or unsecured loans from financial institutions, up to $250,000. The terms were originally for terms of up to 3 years. They would provide a guarantee, but that's now been increased for terms up to 5 years. So that makes it much easier to get debt working capital from the banks. The loans are offered as lines of credit, so you don't have to draw on them if you don't need to. They're available for you. You don't have to draw them down fully. So I hope many of you have taken advantage of that to secure your capitalisation in the current climate. Another well-publicised response has been the prudential oversight of credit quality by Ipara, the Australian Prudential Regulation Authority. That's the organisation that regulates banks. They've been, and not only banks, but also your superannuation funds. You've probably read about the crackdown on the early release of an unnecessary release in many cases of superannuation, which has a very poor economic effect. It sent a couple of super funds almost to the wall. But they've been putting the weights on the bank to give debt relief to struggling businesses in all industries, not just the construction industry, and also to negotiate temporary loan repayment deferrals or holidays for struggling businesses. And then finally, the most, in my view, the most helpful response, it certainly blocks precipitate activity by your creditors, is they put the brakes on liquidation of struggling businesses. It's been nearly impossible to issue creditors' statutory demands or bankruptcy notices on creditors. That's by creditors on debtors. That's the most popular way, the easiest way of collecting a debt, putting a company into liquidation. The nature of it, it's simply a document that's sent to a debtor saying you've got 21 days to pay or make arrangements for payment of your debts. And if during that period of 21 days we don't get paid, then you are deemed to be insolvent, unable to pay your debts as and when they fall due. And then we will go up to the Supreme Court and we will have your company liquidated. We will appoint external administrators to the company and they will run the company in lieu of the directors or in the place of the directors. There used to be hundreds of those issued every week across the country. A large proportion were issued to building companies. However, since the 25th of March, if I recollect correctly, this year, the threshold, the financial threshold for those debts has risen tenfold, from $2,000 up to $20,000. Secondly, the time frame, instead of 21 days, as I mentioned before, it's been pushed out to 6 months. So I've got clients who have issued these things, you know, in the intervening period, and they're remain unable to take any further action. It's essentially given the debtor a 6-month holiday on repayment. Finally, in relation to the insolvency laws, the government gave a temporary safe harbour to directors. Even if your company does eventually fail for one reason or another connected with COVID, as long as you, as the managing minds of that company or that business, have continued to conduct the business in its ordinary course, and not incurred a debt outside the usual range of your business activities, you will not be personally liable for insolvent trading. As many of you will know, a director can be held personally responsible if they continue to trade the company even after it ends, or even after it finishes being able to pay its debts, where, you know, its cash flow has deteriorated to such a point that it can no longer meet its obligations. At the present moment, and it seems it'll remain that way up to the end of the calendar year, if you continue to operate your business and incur debts that are necessary for the day-to-day continuation of your business, you will not be held personally responsible. You have what's called a safe harbour. The company remains liable for the debt, but as I've just mentioned a few moments ago, it's very difficult for your creditors to chase you for those debts. But that's going to change fairly shortly. From the 1st of January 2001, it's likely that those rules that I've just mentioned will come to an end, and Angela is able to explain to you what the new situation will be from that day forward.
So from the 1st of January, some of the COVID relief measures will end. One of them being the moratorium on creditors' statutory demand, as you explained. The notice period will go back to 21 days. So that means that if your company owes money to a creditor, they can issue a notice, and within 21 days, you will need to respond. There's 2 ways you can respond. 1, by paying the amount that's demanded, or 2, by applying to the Supreme Court to have the statutory notice or statutory demand set aside. The ATO tax relief measures will also end. One of them is the write-off that John just discussed in the earlier part of the presentation. From 1 January 2021, the instant write-off will be available for small businesses only with a turnover of less than 10 million, and the threshold will be $1,000. The ATO may also start issuing directors penalty notices and take winding up actions after the 1st of January 2021. Also, the insolvency safe harbor provisions that directors can use as a defense to safeguard themselves from personal liability will also be, will come to an end. But there's other safe harbor provisions that applied before COVID. So John, you have more experience in that area, so you can probably speak to how directors and companies can come up with a safe harbor plan.
Okay. If a company incurs a debt and it has a external administrator appointed to it for one reason or another, by virtue of insolvency, then to the extent that the directors have traded the company whilst it was unable to pay its debts, the ordinary rule is that the directors are personally responsible for those debts. If they knew or should have known the debts could not have been paid, they'll have to pay them out of their own pocket. It defeats the purpose of establishing a company as your business vehicle. But there is a safe harbour. If, as a director, you put in place a documented plan that provides an appropriate outcome, a better outcome than might be achieved by a liquidator in insolvency, if you continue to trade the business, even though you're having difficulty paying the company's debts, you will not be held personally responsible for those debts. You have, as the name suggests, a safe harbour against that liability. But the key to it, the essential thing that you must do, is have a documented plan demonstrating what would happen if an insolvency practitioner was appointed to manage the company and wind it up, and comparing that outcome with your proposal for the continuation of the business. If you continue to run the business in a way that provides a better outcome than would be available to creditors in the event of an appointment of a liquidator, you will be protected. Even though you incur debts and ultimately the company collapses and a liquidator is appointed, you will not be responsible for payment of the debts that you've incurred when you knew the company was in financial difficulty. What that really means is 4 things for you. Firstly, you should seek professional advice. Now, by professional advice in this connection, I mean 2 things. You should get a management accountant, not a tax accountant, a management accountant, to look at your cash flow, predict your cash flow for the next 6 months, plan it out so you can see whether you will ever suffer a point where you can't meet your debts, particularly for a period of 21 days, as Angela mentioned before. If there is an extended period where you can't pay your bills, that needs to be addressed in that cash flow planning. At that stage, you need to seek professional advice from a lawyer, a solicitor, experienced in business rather than in family law or in conveyancing, about how to document your plan, about showing that you're working towards a better outcome than insolvency. And by a better outcome, I mean a better outcome for your creditors, not for yourself. That's the safe harbour planning. You put in place that documented plan about how it goes about. The third professional that you should address is your banking. the sources of funding, whether they're debt or equity capital. Most of your business problems will be overcome if you can raise money to pay those outstanding bills. Recapitalisation, either by selling part of your business, perhaps, if there's something there to sell, if there's a future opportunity for sustainable income out of the business, or by going to the bank, taking advantage of the superannuation guarantee, guarantee arrangements, the cash flow boost arrangements, the SME guarantee scheme offered by the federal government, and using that as debt finance to recapitalise your business. Now, moving on. Now, that's a very brief overview of what's happening with the pandemic in relation to directors' obligations to ensure that companies can pay their bills. I wonder if anyone has any questions at this time.
I've got a question here from George. Could you give us an understanding how and when the proposed registration of company directors will be undertaken, and how will this guard against the phoenixing that currently occurs after liquidation?
Okay.
Interesting.
Exactly how and when, I'm not going to guarantee, to be frank. I was expecting it to come into play next year. Who knows? Your guess is as good as mine, to be absolutely frank. However, when it comes in, and it's certainly on the cards, it will happen. It's just a matter of when. When every director has to identify themselves and be given a number, it'll be much easier for the ATO and the ASIC to track errant directors. It'll be much easier for them to stop the practice of phantom directors being appointed. If anyone's been around in the early 80s, you remember bottom of the harbour schemes. Lawyers like me would walk down to the domain, get a couple of derelicts to sign up for a bottle of wine. They'd sign the consent form as a director. A lot of good they would be. Nowadays, the practice is just to make up a name. Mr. Homer Simpson of 1 Spring Street, Springfield, USA, will be a director of the company. Thank you very much. Sign here. Doesn't exist. Can't prove a thing. The directors will have to identify themselves as real, live, living people rather than complete phantoms. It will reduce a degree of phoenixing in that way. The other thing will be the increased capacity of ASIC to enforce the laws limiting directors, both their duties of care and skill, of diligence, of not trading the company whilst insolvent, which has been the focus of this presentation, their general duties of care and skill, and also to ensure that they're not transferring assets at an undervalue to related entities that aren't identified in the company documentation. I hope that answers your question.
Yep, I'm sure it does. That's the only question we've got. Can I ask a question back to the last presenter with it? Presenter, I don't know how to say that word, that we had. Have you guys got experience in product failure and representing builders against those suppliers, and how's that gone? You got any?
I acted for
stories?
CSR Building Materials for 5 years, so yes.
You what? You work for them?
Not internally. I worked at a firm where we had all the litigation that CSR Building Products got involved in.
Right.
Which was a pretty broad range of materials: plasterboard, concrete, bricks, tiles, compressed fibre cement. I'm sorry, the lights have just gone out here.
And what's the general approach? Are they helpful? Are they willing to reach into their pockets and fund, admit fault? Like, how do they normally handle it at that scale?
Each business unit had a different approach. I'm not at liberty to tell you anything about how they treat legal claims, obviously. I thought they were fair. Cruel but fair.
Cruel but fair. I guess, I mean, the challenge for us, like against a company like CSR, if we have a bad batch of gyprock or roof tiles or whatever, we're such a small business. We don't have any depth and funds to pursue legal cases against the CSR, for example. So it makes it very difficult, I think, for us little builders to operate, you know, when we're getting stonewalled by a big corporate like that. Which I don't know what protection and what options do we have as small builders to get them to come to the party?
You've got one very great advantage. It's competitive business or commercial advantage. And that is that, to use my example of CSR again, they have a rabid competitor, Boral. Switch suppliers, play one against the other.
Yeah, but you know, the amount of gyprock I buy, the amount of gyprock I buy for all my projects for the whole life is barely going to be a rounding error in CSR's balance sheet. So me switching to Boral is not going to mean much. Whereas the defect for me to rectify could mean the difference between being insolvent or not. So it's.
I guarantee you, if you approach Boral after you've had a problem with CSR, they'll welcome you with open arms, and you'll get some significant competitive pricing from them.
Yeah, but still, it's not going to weigh up much against a $50,000 defect rectification, if that's what it is. You know, it's
True. Well, come and see us, and we'll help you with that.
Yeah, I know. All right, thanks a lot, guys. Appreciate your time.